Did you know that the Supreme Court of the Philippines ruled a taxpayer doesn't need excess input VAT from output VAT to claim a refund on unutilized input VAT from zero-rated sales? How does this impact businesses and tax collection in the country? Learn it here in the case of Chevron Holdings Inc., formerly Cultex Asia Limited, versus Commissioner of Internal Revenue, GR number 215159, promulgation date, July 5, 2022.
This is the 21st of the 160 cases penned by Associate Justice Mario Lopez, 2024 Bar's Examination Chairperson. Subscribe for more similar contents.
Facts of the case. Chevron Holdings Inc., a corporation registered in Delaware, USA, and operating in the Philippines as a regional operating headquarter, ROHQ, rendered services both domestically and abroad in 2006. Services to foreign affiliates were taxed at a 0% rate, while those to Philippine affiliates were subject to a regular 12% rate. Chevron Holdings incurred input taxes on these purchases. In 2008, Chevron Holdings filed administrative claims for refunds or tax credit certificates on unutilized input VAT attributable to zero-rated sales to foreign affiliates. The Commissioner of Internal Revenue, CIR, did not act on these claims, leading Chevron Holdings to file petitions for review with the Court of Tax Appeals, CTA, Division. Initially, the CTA Division denied the petitions, deeming them prematurely filed, as they were lodged before the CIR's deadline to act on the request. However, the CTA and Bank later reversed this decision, ruling the judicial claims as timely filed. The CTA and Bank partly granted Chevron Holdings petitions, acknowledging the zero rating of sales of services to non-resident foreign affiliate clients under specific conditions. However, it observed that some foreign clients lacked adequate documentation, and some sales lacked the required inward remittances, leading to the disallowance of certain amounts. Further, the CTA and Bank noted that there was no excess input VAT for a refund for the second, third, and fourth quarters of 2006, while for the first quarter, only a small amount was refundable. The CTA also disallowed a significant input tax amount due to non-compliance with invoicing requirements under the tax code. Chevron Holdings then filed a petition for review before the Supreme Court, raising issues related to the qualification of its zero-rated sales, inward remittance of sales in foreign currency, recognition of excess input VAT carried over from previous quarters, and disallowance of a refund of its excess and unutilized input VAT.
Primary issue. The primary legal issue concerns the refund of unutilized input value-added tax, VAT, from zero-rated sales, focusing on whether the taxpayer needs to have excess input VAT from the output VAT to be entitled to a refund, as the law does not stipulate this requirement.
Supreme Court decision. The Supreme Court partially granted Chevron Holdings' petition. It clarified the conditions under which a taxpayer may claim a refund or issuance of a tax credit certificate for unutilized input VAT attributable to zero-rated sales. The court emphasized that the taxpayer must prove non-application or non-charging of the input VAT subject of the claim against the output tax. Chevron Holdings failed to demonstrate that certain services to non-resident foreign affiliate clients qualified for VAT zero rating, impacting the amount refundable. Important doctrines discussed. 1. Refund of unutilized input VAT from zero-rated sales. The Supreme Court clarified that a refund request for unutilized input VAT from zero-rated sales cannot be denied simply because the taxpayer does not have excess input VAT from the output VAT. The court emphasized that the law does not require this for a taxpayer to be entitled to a refund.
2. Computation of refundable input tax. In cases of mixed transactions, involving VAT-able, exempt, and zero-rated sales, The refundable input VAT is computed by proportionally allocating the validated input taxes to the zero-rated sales based on sales volume. 3. Supreme Court's role in tax refund claims. The court holds the view that it should not hesitate to grant a refund when the claim has a clear legal basis and is sufficiently supported by evidence.